Hi guys, welcome back to the channel. Crime Wine Murphy. Kouri Richins will be having a 3-day preliminary hearing today. In about an hour, court will start. So I am just putting what happened at the pre-trial hearing the other day, and that was about to take her handcuffs off while she's in court so she can write and communicate better. Because, every time she's been in court, she's had to wear handcuffs, shackles. And so they'll take the handcuffs off. Well, so they should. And this trial today that starts later is going to last 3 days, around 3 days. And we'll see if this will go to trial. They've been trying their hardest to suppress evidence and everything like that, throw stuff out. Well, we'll see how it goes today. Today we're going to hear a lot. We're going to hear a lot of information. It's more or less they're going to tell us what the case is about, and yeah. So, but before that, I'm just going to show this short 25 minutes of the hearing from the other day. And thanks for stopping by, and don't forget to watch my videos. I need watch hours, guys. That means you have to watch them. That helps me out. Thank you very much. See you in a bit.
Very good. And then on behalf of Ms. Richins, who is present by WebEx.
Kathy Nestor and Wendy Lewis on behalf of Ms. Richins, who's also listening in.
Okay. We're here on a couple of evidence-related issues in anticipation of the preliminary hearing that's coming on Monday. I have a few questions, and then I understand there are a couple of 1102 statements that we need to discuss. Do you mind if I just start with my initial question so I don't forget?
Sure.
First, Mr. Bloodworth, there's a binder of exhibits 1 through 65, right?
Yes, Your Honor.
When am I going to get that?
Your Honor, you have that from the May.
I'm not sure I do.
The minute I leave here, I can bring you a copy.
Sounds good. I understand that the parties have agreed that that will not be made part of any public filing, but it still needs to go into the exhibit room so that, for example, if Ms. Richins wants to file a motion to quash bind over, she can get a copy of it and there's no ambiguity as to what the exhibits were. There's no objection to that, correct?
Correct.
Okay. The 1102 statements, I'll need a stack of those as well, right? Can I get them at the same time as the binder?
Yes.
Okay. The trial brief that the state filed refers to witnesses by number, but the most recent filings refers to them by initials. Can I get a conversion chart so I know who is who?
Yes, Your Honor.
Okay. I think that will help all of us make sure I understand who we're referring to, which 1102 statement we're referring to.
Correct.
Okay. If you would do that for me in the next day or two, I'd appreciate it.
We'll have it to you today.
Okay. The docket entries that counsel has agreed will be admitted as exhibits. They're in the public record. They're accessible. I don't know that I need another. Do we need a copy of those for the exhibit room, Brittany? If you would print off a copy of those and submit them with the binder for the exhibit.
Yes, Your Honor, they're there.
Okay, very good. All right. Then I just want to confirm, Ms. Lewis, Ms. Nestor, with respect to the 1102 statements of witness 1 and witness 2, I don't know their initials. yet, but they are the two witnesses that Eric Richins called, I think in February, when he had some reaction to something he ate. Is the defense objecting to the admissibility of those or any part of those 1102 statements?
I want to make sure, because I also am not clear on the numbering of the witnesses. I also have been referring to them by initial. So if maybe Mr. Bloodworth could help with that. But
Yeah. I think I can.
Okay.
I can clarify that. So the state will not be presenting 1102s from those two witnesses.
Okay.
For the court. The state will call one of them, maybe two, but we will not be proceeding by 1102.
okay.
When they are called, will they be testifying, or will the state be seeking to elicit testimony from them regarding what Eric Richins told them over the phone, for example, at 1:59 p.m. and 2:11 p.m.?
Yes, Your Honor.
Have you all had a conversation about whether those statements are subject to an exception to the hearsay rule?
Your Honor, counsel for the two parties have not had that conversation. I could explain why there are exceptions. If we want to argue and address that today, I can do that.
We don't need to. I'm sorry, Ms. Nestor, go ahead.
I'm sorry, we have a slight delay on the WebEx. I'm sorry, Your Honor, I didn't mean to interrupt you. So we objected to both of those 1102s for exactly that reason. And the prosecution has agreed to call them in person, and has withdrawn the 1102s. I would anticipate that we would object to anything Eric told them. But I assume they have an argument for why they think it should come in, but we do anticipate objecting to that.
Okay. We don't need to address this today. To the extent the state or the defense wants to preview their positions on the admissibility of those statements by Eric to each other or to the court, I'll consider whatever you file. I have my own questions, and so I don't want there to be any surprises if I ask them or if we have this conversation during the course of the preliminary hearing.
Understand, Your Honor.
Kouri
All right,
was
very
not in
good.
court. She was via Zoom.
That was the end of my questions. Let me make sure, Ms. Nestor, did you have anything to add on the questions asked by the court so far?
No, Your Honor. Okay.
I think that brings us to the 1102 statements of, I'm going to get the initials wrong here, forgive me.
CL and HJ.
Let's handle HJ first. That's the short one, right?
Yes.
Ms. Nestor, what is the defense's concerns regarding the reliability or admissibility of the proposed 1102 from HJ?
Your Honor, as the court is aware, under Rule 7B of the Utah Rules of Criminal Procedure, the state is authorized to use in whole or in part what is called reliable hearsay. And, you know, the entire statement is hearsay because it's made by a declarant who's out of court. Then Rule 1102 gives us some guidance as to what the definition of reliable hearsay is and gives us a list of what types of statements are considered reliable hearsay for purposes of Rule 7B. And we do not believe that the statement by HJ meets any of those. And just real quickly zoom through them. The first would be whether it would be hearsay admissible at trial. Obviously, this is just a classic hearsay statement. It would not be admissible at trial. It also would allow...
May I stop you there for a second?
Yes, sure.
If we can go one at a time. HJ's out of court statement might not be, but Ms. Richins' out of court statements, why wouldn't they be categorically non-hearsay as an admission of a party opponent.
Hers, I think, would be, but his statement would not be. So I'm
Okay.
basing it on his statement.
Understood.
Because without his statement around it, the context, it doesn't really make any sense. The second ground would be hearsay that would otherwise be admissible for an unavailable witness under Rule 804. But under Rule 1102, admissibility is a non-factor. It doesn't matter. So in other words, whether someone made former testimony under oath, which this is not that, if it's a statement under belief of an imminent death, I believe HJ is still with us and did not believe he was under fear of imminent death. A statement against interest, again, doesn't apply, or a statement of personal or family history doesn't apply. So that exception or that definition of reliable hearsay does not apply. The other one would be if it has something to do with laying a foundation for authenticity of a document. And Your Honor can see we've bent over backwards for purposes of this prelim. We've not challenged authenticity of any document.
May I ask you a question?
Yes, sir.
Why doesn't this qualify for admission at a preliminary hearing under Rule 1102B8B? Just like every other 1102 statement typically comes in under B8B.
Well, Your Honor, we don't have any evidence that this was a statement that was transcribed verbatim. I guess probably the closest it would come would be number 8 would be the reason. And just for purposes of the record, I assume you're talking about a statement that's written, recorded, transcribed verbatim, and sworn or given under notification of perjury punishment, right?
It's the latter, right? Like the opening paragraph says, I understand if I make a false statement, I'll be subject to a Class A misdemeanor. This is the language that we typically see in the preamble of 1102 statements. Right. Now, I'm not suggesting that immunizes everything that follows from other consideration under the hearsay rules or the reliability concerns. But if we have a witness saying under potential criminal penalty for making false statements, I had a conversation with the defendant in which she said X, Y, and Z, and I said A, B, and C. Why isn't that admissible as reliable hearsay under 1102?
Well, I think part of the reason it lacks reliability and part of the reason that we have an objection to it being considered for purposes of establishing probable cause is simply the lapse of time. So this statement was signed, I want to say 2 years after Mr. Richins' death. There is no context for why this individual allegedly remembers the date or timing or specifics of a call. And the first time he ever discusses it is 2 years later, when there's been massive publicity about this case, about the facts, about, widely available to anybody that wants to read the facts of this case. So we just feel like it lacks the normal indicia of reliability. For example, and I think this number 8 definition of reliable hearsay is more geared towards witness statements that are taken at or near the scene. In other words, when a police officer, interviews someone at the scene of a homicide and says, hey, tell us what you saw, and they sign their statement, and they put their date and their name. This is not that. This is a situation where 2 years later, he hires a lawyer. He and the lawyer show up, have an interview at the county attorney's office. The county attorney then goes back into and I'm not suggesting this is improper, but this is what happened. And it happened before the law changed, which prohibited district attorneys or county attorneys from drafting the statement themselves. That law changed in February. So this all occurred before that. So I'm not suggesting any improper conduct. But what happened was the county attorney went back, listened to the interview of this gentleman, pulled out quotes from it, and put it together in a statement and sent it to the lawyer for the guy to sign. So I also think it doesn't meet the requirement of the new law that the prosecution not be the person that drafted it.
as long as all they do is create an exact transcript of recorded statements, I think it would comply with the current version of the law as well, right?
I expect that's what Mr. Bloodworth will argue, but I do feel compelled to raise it.
Okay. Ms. Nestor, you acknowledge that the court's authority to make credibility determinations related to, man, these events occurred a long time ago. How could you possibly remember this? I'm precluded from doing that at a preliminary hearing.
I agree, except I do think you bear somewhat of a gatekeeper function in terms of not letting unreliable evidence even be put on that scale to consider what tilts it in favor of probable cause and what doesn't. So I would just lay it out that way.
I understand. Okay. All right. I understand your position regarding this one. Mr. Bloodworth, I think I have this firmly in hand. Anything to add about the 1102 of HJ?
No, Your Honor.
Okay. Ms. Nestor, I appreciate the argument. It's made in good faith. Under Utah Rule of Evidence 1102B8, and having reviewed the content on the face of this witness statement, the court is overruling the objection and ruling that the proposed 1102 statement of HJ is admissible for the sole purpose of the preliminary hearing under Rule 1102B8B.
Thank you, Your Honor. Just for purposes of the record, we respect your ruling, but we would like our same stipulation that we are preserving our right to object to it ever being offered again, other than outside this prelim hearing.
Understood. That's part of the record.
Thank you, Your Honor.
Okay. If then we move to the 1102 of CL, same objection or more or different objections?
A little bit different on this one. It appears, and it's written in such a way as to, I think, avoid this problem, but it still is relying on multiple hearsay statements of other individuals. Again, I concede that any of Ms. Richins' statements are going to fall under, the statement of the party opponent exception. But she refers to multiple other individuals that told her things. They're clearly being offered to bolster her claim. And we just don't think those references meet the definition of reliable hearsay under Rule 1102.
So I gave that some thought as well. And so let's take this one layer at a time. To the extent the statement constitutes an out-of-court statement by CL, the court rules that it is reliable at that level under Rule of Evidence 1102B8B. To the extent we go to the next level and we're talking about CL stating what Kouri Richins told her, that is not hearsay because it is a statement by a party opponent.
Right.
To the extent she's saying what somebody else besides Kouri Richins told her, I think it can come in for the effect upon the listener. That is CL. That is to provide context for why she did or didn't do whatever she did or didn't do next, but not for the truth of the matter asserted. Do you see it differently?
I think that would probably be proper if the court considers it only for that purpose, and we would ask that the court do so.
I mean, my understanding, Mr. Bloodworth, is it's what CL did and their interactions with Kouri Richins that is the probative part of this 1102 statement. Is that correct?
That's correct, Your Honor. And yes, the state agrees with the court's view that the extra or additional potentially hearsay material is not hearsay because the state's not offering it for the truth of the matter asserted.
Okay. I think we have a common understanding regarding how the court will use, if at all, this 1102 statement.
Thank you.
Anything further, Ms. Nestor?
Again, just I'd like to make the record that we would obviously reserve our right to object to it for any other purpose other than the preliminary hearing.
Of course. Okay.
I do
Ms.
have
Nestor?
I do
Yeah,
have
go
one
ahead.
more thing about 1102s. I realized this morning, we were given a late production, not a late, there's no deadline, but we were given a recent production of an 1102 from a forensic, toxicologist. I'm not totally sure, Slauson. And we forgot to include that 1102 in our agreed exhibits because it came not with the other ones and I just lost track of it. So we actually, that one is going to fall under medical or autopsy lab reports, scientific reports. It's clearly going to meet the definition of reliable hearsay. We don't object, but I would like to put on the record that we may certainly reserve our right to object at an actual hearing after this one or a trial. But for purposes of the prelim, we also agree that would properly be considered by the court.
Okay. Anything to add on that, Mr. Bloodworth?
No, yeah.
All right. That'll be included in the stack the court receives.
Yes.
Okay. All right. Ms. Nestor, Ms. Lewis, anything else on the record today?
The only issue we wanted to raise, and I know this puts you in a difficult spot, but I just need to ask. So we expect these hearings to be pretty lengthy. They're going to last, I think, most of the day, Monday and Tuesday. I'm hoping we don't go to a third day, but if we do, we do. We're going to try not to. But Ms. Richins has been at the last couple of hearings. Her wrists have been bound by metal manacles, handcuffs, whatever we want to call them. And it makes it very difficult for her to write. And it makes it difficult. We prefer that she writes because if she speaks to us when we're listening to a witness, it's very distracting and we can't focus on the witness. And it's also a little bit painful to sit in those for 3 straight days. And we just have not seen any evidence that she's a danger in the courtroom. We would have, guards standing right there. We don't object to her, whatever other security measures they need to take. But we as the defense team do not feel any threat. We feel very safe sitting next to her. We would ask that the court please consider allowing her to remove those handcuffs during the prelim.
I'll consider it. I need to check with the Summit County Sheriff's Office. I don't want to make this decision in a vacuum. And so I'll consider the request and you'll know one way or the other by Monday morning.
Thank you, Your Honor. And what time did you want us? Did you want us starting at 9 or 8:30 on Monday? I was a little bit confused about that.
I have it scheduled for 9:30. I've got a little boy. I got to make sure it gets to school. Any objection?
No, we are not morning people. That's great with us.
9:30.
Okay, 9:38.
One other thing, I guess I know you wanted all housekeeping matters out of the way today so we could just get going on Monday. We did reach an agreement this week with the prosecution. We've got obviously families on both sides here that are very, very invested in what is happening in this case and to their loved ones. And we're trying to respect that. It's just impossible for us to know at this stage who our witnesses at trial will be. I mean, we're just so far away from that. So what we did was we reached an agreement that the immediate family members of Mr. Eric Richins, the decedent, and the immediate family of Kouri Richins, we agreed we would not invoke the rule with respect to those people and that they could attend the hearing. I did look at the rule and it does say the parties can agree to, so we're hoping that Your Honor is comfortable with that. It doesn't apply to any other people that are fact witnesses or the people that wrote the 1102s or anything like that. It just applies to Kouri's mom, brothers, their wives, and her aunt, and the Richins, sisters and their spouses and his parent. And I think that's it.
Mr. Bloodworth, is that correct?
That is correct.
Okay. I think we also need to acknowledge that this case has attracted a lot of attention. There will be a lot of people listening in to the audio only WebEx access that will be provided next week. And so I simply won't know to a certainty who's listening at any given time. You need to have control of the witnesses that are not among that immediate family group.
Yes, sir. We've talked about that. We're not really sure how to exercise that control, but we will do our due diligence and make sure we warn all the witnesses that, that's not proper.
Okay, very good.
Your Honor, speaking of audio only, apparently that's where Mr. Ramos is.
He is-
So
I can fix that. My apologies.
Come to the hearing. He's here, but he couldn't get a video, which is fine for today, but that's where he's at. Oh,
He's
there
in
he
there.
is.
My apologies. Okay. Do you folks feel like you have sufficient space in the courthouse to have a place to confer, get organized if you need it?
Yes, the county attorney's been very generous and reserved us a conference room. We appreciate that.
Okay.
We right now only expect to maybe call one or possibly two witnesses on behalf of the defense. So, and then I think the prosecution is only calling 4, maybe 5. So we really are hopeful, Your Honor, we don't waste a third day here, that we can try to get it done in 2 days. But if we can't, we can't.
Okay, I understand. Mr. Bloodworth, anything else on the record today?
No, sir.
Okay. Folks, I appreciate your patience in getting on the hearing on short notice. Look forward to working with you at 9:30 a.m. on Monday morning. Courtroom